Thank you, Acting President. I rise to speak on the Inquiries Amendment, Yoorrook Justice Commission Records and Other Matters Bill 2024, a bill which seeks to make some amendments with respect to data and records keeping to enable the operation of the Yoorrook Justice Commission, which is a groundbreaking process underway in this country, being led by this state to get to truth about the past injustices and the ongoing impact of those injustices felt by the Aboriginal community here in Victoria. Before I go into the detail of the bill, I did want to take a moment to reflect on why both the Yoorrook process is important and why it's important for us as members of this place to be doing all that we can to support its effective operation so that we can get to the truth that it seeks. The history of dispossession and injustice felt by Aboriginal Victorians should be well known to many in this place and many in the community. Sadly, it's not very well known to some, to many. And part of the process that we as a community need to go through to better support our First Nations Victorians thrive in our community, overcome the injustices of the past, is to understand what they were and how their impacts and how those actions impacted and continue to impact on Aboriginal Victorians. I reflected at the earliest opportunity I had to speak in this chamber at the beginning of 2023 on the special responsibility I feel that members of Parliament, particularly those sitting in this chamber, have to both understand, acknowledge the injustices of the past and commit ourselves to fixing them. Because it was within these gilded walls that the laws were passed to enable the dispossession of Aboriginal people from their lands. It was the laws that were passed through people who were only able to sit on these red benches because they had property that was the result of the dispossession of the first inhabitants of the land that we now call Victoria. And the laws that were passed here, removing people from their connection to their land, removing children from their families, outlawing culture and language, those laws were passed by our predecessors on these benches without the input of Aboriginal Victorians, who didn't have a say over the laws that were being put before this Parliament. So I think we've all got an obligation when we consider the bill before us today and we talk about voices and we talk about classes of citizens, to remember that the things we're trying to overcome, the things we're trying to acknowledge so we can begin to redress them, were done by this chamber without the input, without the consent, without any form of democratic connection to members of the Victorian community they directly affected, Aboriginal Victorians. That's the starting point for this debate. The history of dispossession in this state and the role that our predecessors in this chamber, who sat here by dint of their propertied interests until the middle of last century, have. That's where we start. What the Yoorrook Commission is designed to do is to shed light on those injustices of the past, to understand how the laws that we passed, the statutory office holders that we created, the empowerment, the funding that we gave to various parts of the state apparatus here in Victoria, how they impacted on dispossession, forcible removal, created criminal justice systems that discriminated against First Nations people here in Victoria. The Yoorrook Commission is designed to put that truth on the table. And it's a remarkable thing that it's taken so long for it to start. And it's even more remarkable that we have so many willing to come forward and share the pain and the anguish that they still feel, and the stories that Aboriginal Victorians have been willing to tell to the Yoorrook Justice Commission is doing our state a great service so that we can understand and we can learn and we can commit ourselves to creating a future with Aboriginal Victorians instead of for Aboriginal Victorians. And this bill today, which the opposition don't support, which they are opposed to, is about creating the necessary conditions in terms of the stories and the voices to enable that partnership to continue into the future. That's the crux of what we're at here today. That's the context of why we're here, not just because of this bill, but because of the bills that came before it over the last 170 odd years of this chamber's existence. And thinking about the failings of the past, we've got to think about what a better approach might be in the future. And the fundamental principle, or a fundamental principle of the Yoorrook Justice Inquiry has been that First Peoples here in Victoria must be able to engage with the truth-telling process on their terms, on their self-determined terms. And at the heart of this legislation lies a simple and indisputable truth that First Peoples can only truly thrive when they have the power to determine their own future. This concept of self-determination, which underpins things like Indigenous data sovereignty, is not a new idea. But governments across the country struggle still to put into practice this concept. And we know from past inquiries that have exposed horrific injustices and practices. The Royal Commission of Deaths in Custody as one, the Bringing Them Home report by the Human Rights Commission as another. How challenging it has been for First Peoples to tell their truths. And we know that many of the stories that the brave members of our community here in Victoria, brave Aboriginal Victorians, have come forward and told to Yoorrook have never been heard in public forums before. And we know that Yoorrook's work and the value of that commission rests on those stories being told, so that we can hear them and that others can hear them, and that we can learn and make decisions for the future. And what this bill seeks to do is to bring that principle of self-determination, which should underpin a successful partnership going forward, to life by ensuring that First Peoples have their own stories and the evidence they share with the Yoorrook Justice Commission. Part of the process that the Commission has gone through to find ways to ensure that that truth-telling and storytelling can be done openly and honestly is for First Peoples to understand how the information that they were telling to the Commission would be used once the stories had been told, both for the purposes of the Commission but then also at its conclusion. And that's where the concept of Indigenous data sovereignty plays such an important role, which is the right of Indigenous people to own, control, access and possess data that derives from them and which pertain to their members, knowledge systems, customs, resources and territories. And as a result of the extensive engagement that the Commission did, the Yoorrook Commissioners did, they've sought this legislative change so that these choices are upheld by the State of Victoria once the Commission ends its work at the end of June 2025. And the changes will ensure that additional protections for First Peoples evidence, so the Commission can guarantee definitively that First Peoples who shared their truth will have choices about access and use of the evidence respected. This government, through this legislation is respecting that request and supports the Commission's commitments by enshrining them in this bill. The Inquiries Act is going to be amended to provide the Commission with the power to make two types of orders, to either close or restrict access to certain records. One is an order to close records once the Commission ends, and that will prevent First Peoples evidence being publicly available within the Public Records Office of Victoria or via FOI requests, thereby preventing secondary access and use without the consent of the record's author. So without consent, use won't be available. The very heart of self-determination and control over stories and truths is that the people who have those experiences get to decide. And the second is a record order to restrict access to certain records once the Commission ends, and that will be a power to make records relating only to First Peoples evidence. So not about the other evidence that the Commission is receiving from non-First Nations, non-First Peoples, for example, by government representatives for other organisations. Though that public evidence from public sources, from public institutions, from governments and the like will be available, but the records from First Peoples will not. And that's due to the sensitive and personal nature of many of the accounts provided in the evidence. The reforms are about authors of the records retaining access in full, so people will still be able to access their own stories and records and be able to share, publish or copy or use the records in any way consistent with Victorian law. The Commission has provided first sets of reports which have, I think, shone a very stark light onto some of the issues that still confront Aboriginal Victorians and contain some pretty harrowing accounts of dispossession and injustice. We're due to receive, due to provide 2 more reports, and has a collection of evidence from elders, ministers, leaders from across the community on the website. The process that got us here has been one of engagement and consultation. So the Yoorrook Justice Commission has engaged with members of the First Nations community, with the First Peoples Assembly. It's also worked with the Public Records Office to ensure that the provisions of the bill align with other legislative requirements. Drafts of the bill were also shared with the Office of the Victorian Information Commissioner and the First Peoples Assembly for their feedback. The reports from the Yoorrook Justice Commission will serve as important historical documents, but they'll also serve as important building blocks for the work that the government is doing as we move towards treaty. Truth-telling is an important part of the treaty process. It's an important way that we acknowledge where we are and what's happened in the past and the ongoing effects of those actions. It also provides us with guidance on how and where the treaty-making process should embark upon the issues that need to be addressed, because it has been a long journey since colonisation here in Victoria for Aboriginal Victorians, and there is so much that has happened in terms of systemic exclusion from opportunity, dispossession and discrimination. The bill today plays an important role in ensuring the work of the Yoorrook Justice Commission has that truth on the table, that allows the principles of self-determination to be put into practice, that the stories that are being told, the truths that are being told, remain within the control of those who are telling them, so that they have the ability and the power over their stories and their lives in a way that for so many, for so long, were disempowered by the laws that were made in the state of Victoria by those who stood in this chamber before us. We have an opportunity by supporting this bill today to take another step towards righting some historical wrongs, supporting the principles of self-determination and getting closer to truth, and I commend the bill to the House.